Brenda Simpson has just received a phone call from the Tennessee attorney. His attorney is asking for more time. He has a deadline of June 22 to file the state's answer to her petition for appeal in the Tennessee Court of Appeals. He wants an additional 20 days after having been given by the court an additional 30 days. His initial petition for extra time was on account of a busy schedule. And she, getting his phone call, said that's fine, and she did not disagree. But he called her today wanting an additional 20 days to answer. So in other words, 50 days that he and his team of lawyers at Jonathan Scrimetti's office in Nashville to answer her petition. Her petition is one that I'm confident is making these men defecate in their fruit of the looms, because she is challenging, without precedent, the entirety of the criminal apparatus operating in Tennessee as against traffic allegation cases. Ms. Brenda says that because driving and operating a motor vehicle constitute a privilege, that she was improperly criminally prosecuted in Henderson County. She was convicted by a jury on 3 traffic misdemeanors. She's saying that because the matter is in the privilege law, that she and all other accused parties have a right to be heard in the Department of Safety. And the grounds are that the state always has a duty to exhaust its administrative remedies. And in controversies under the executive branch departments, all controversies are heard in departments first, with a few exceptions. And that is because departments are where the knowledge resides on particular matters. And also departments are where permissions, licenses, permits are given. And so since driving and operating a motor vehicle constitute a privilege, she had a right to be heard in the department. And she said, it says in her petition, it is invidious class discrimination for the state to move criminally initially, that the state must exhaust its administrative remedies under numerous cases, such as Colonial Pipeline versus Morgan, that talk in detail about the administrative process. She's saying the state cannot jump to the last provision in the law, which is the penalty provision, and enforce that. No, the state must move slowly through the ranks, through administration, and then through adjudication. That is to say, the case is administered by the Department of Safety in Nashville or a Department of Safety branch in the local county. And then if there's a loss, the losing party can appeal. And where does the appeal go? The appeal is in chancery. That's how the law is set up. All privileges are heard this way. We have about 50 privileges in Tennessee, and all of them, when there's a disagreement or an allegation, they're all heard, all of them, whether it's embalming or plumbing, are heard in the respective commissions or boards. And she's saying that also is true for the driving and operating a motor vehicle privilege, which is under the utilities section of the law under carriers. The motor vehicle title in 55 is the carrier statute detailed, right? Title 55 is particular, the motor vehicle code is the particulars of that trade and profession. And so she is making an unprecedented challenge, and they cannot figure it out. They are beside themselves.